I want you to envisage, if you may, a set of stairs where you have to climb from the base to the top of that staircase. And then understand that really to get to the top, it is best to go step by step. So even in litigation, we are starting in terms of case management to see it from this perspective, that you are going to take your dispute through various steps, through various stages, and hope that one of those stages will resolve that dispute that you have with somebody else. And we normally have this scope of variance, that at the bottom of the staircase, one of the best way is to resolve a dispute is to prevent it. So prevention is a very important way of resolving disputes. And at the top of the staircase is perhaps what we would call civil disobedience or violence. When you're in a dispute, you may find yourself engaging in a fist fight, and then you feel that because you have won the fist fight, you have resolved the dispute. Probably not, and probably it will escalate into other issues, perhaps of a criminal nature, as the case may be. But the point which I'd like to emphasize is that there's all this in between that needs to be explored. And that moves from areas like negotiation, mediation, arbitration, litigation, and then the top stair, which we have just discussed. The challenge that we have in the court system, what we see is that people jump from the bottom of the stairs to nearly the top. And so they come into adversarial litigation as their first port of call. They do not try to negotiate out the situation, or if they do not put in their best efforts in resolving it. And this is quite easily seen from the kind of letters that come out of our law firms. The moment you get instructions, you write what is now well known as a letter of intention to sue. And that already sets the mind frame that if you don't agree, we shall go to court. This is something that has remained with us. But even in the countries like the UK, where we borrowed most of our legal processes, the people no longer write letters of intention to sue. They write letters of demand. And in the letter of demand is this staircase that I have indicated. They will normally say that you're invited for a discussion. Yeah, if you fail, we would like to try a mediation. If we fail, etc., we can go to litigation. But for us in Uganda, we have been fixated on litigation, and the results are out there for us to see. The courts are full. But even if we say that the courts are full, you know, we just have to remember, for example, the Hill report. The Hill report on dispute resolution in Uganda gives some very interesting insight that even though our courts are full, only 5% of all disputes in Uganda actually come to the courts. Now, if that is so, if only 5% come and we allow more to enter, then we'll have a crisis in the courts. But also the report came out with another interesting statistic that even with that 5%, only 3% of those disputes have legal counsel in representation of parties. And so that really should give us some food for thought in what is the structure that we should be addressing our minds to in terms of dispute resolution. Now, even though we had a bit of conceptual challenges as to whether we could or could not start appellate mediation in Uganda, other countries have perfected appellate mediation. So this is not something that is new. And many states in the US have actually onboarded appellate mediation. So that one is working. And even the Court of Appeal in the United Kingdom has also started appellate mediation. I have given you a case there of Frank Paul versus Plymouth City Council. There is a very interesting speech by the former Chief Justice of UK, Lord Wolf, when he writes on the need for appellate mediation in the Court of Appeal of the United Kingdom. And so I would implore you to do some research around this, how appellate mediation is growing, especially in the common law countries. But perhaps one of the well-documented examples is that of the North Carolina Court of Appeals. Their website has a very good brief on how appellate mediation works. And I refer to the North Carolina Court of Appeals because I have found that what they are doing is very similar to what we have been trying to design in Uganda. And so they define appellate mediation as a voluntary program that allows parties to an appeal to submit their dispute for mediation by an informed, neutral person in a confidential setting. So very much like what you'd have in normal mediation by way of definition. What we're doing there is we are introducing a third-party neutral to help a discussion between two parties to a dispute. And in the North Carolina situation or program, they have sitting justices who may be involved in hearing these mediations or participating. They sometimes recall retired justices, and they also have others who come, very much like the system we have in the trial courts of what we refer to as court accredited mediators. So in terms of basic concepts, I think that is what it is. It is not very different from trial mediation. It is a voluntary program, and it is really with a view to have that appeal settled. Now, in North Carolina, several things may happen. First, if the mediation is successful, then the appellant is responsible for moving to dismiss both the appeal and any case in the trial court that may be there if necessary. And this is what we have also been able to do. We have had cases in the Court of Appeal which have come to the Court of Appeal, but there is a multiplicity of relatives in the trial courts. I remember there's one where I think one of them came to appeal, but there were up to about 15 similar disputes in the trial courts, both at the High Court and at Chief Magistrate's level. But because the appellate mediation was successful, we were able not just to close the appeal at the Court of Appeal, but we're also able to close all the files that were pending hearing in the High Court and the various chief magistrates courts. Now, on the flip side, if the mediation is not successful, then of course the appeal will proceed in the normal way. And if it is to be conducted by a private mediator, then the mediation report should be given to the clerk of the court within 5 days. So even in our situation, as you get to learn, this is a back end. So really, those of you who come to the course will not see it. But for every mediation that we do, we write a mediator's report, which is kept on the file. So, but that is normally not very visible to the parties, but it helps the court in managing the disputes before it. So if you are to look at the characteristics of appellate mediation, like I have said, very much like trial mediation, the idea is to settle. And you know that settlement can take place at any time before judgment. Rule 2.2 of the Court of Appeal rules give us a wide inherent power to make such orders as may be necessary for the attainment of the ends of justice. So the destination in all of this is justice. It is within that is also equity, fairness, and agreement between the parties who are at dispute or in dispute. Again, just to emphasize, it is a voluntary process, and therefore it requires buy-in. And this is where some of the challenges which we shall discuss come from. But by its very nature, ADR is a voluntary process. There was some misunderstanding, I recall, when we were involved in trial mediation, when we said that mediation was compulsory. It was, I think, misunderstood. Perhaps the wording was not so well done. The procedural aspect there was that it was compulsory to attempt, but it was not compulsory to complete. It was just giving an opportunity for parties to explore, because in Uganda, we have a history of going straight to litigation, as I have said earlier. And it is open to all nature of appeals of a civil nature that come to the Court of Appeal. So not open to criminal, but open to all civil matters that come to the Court of Appeal. Another characteristic is that the resolution is party-driven as opposed to the court. This calls for creativity, innovation, and mutual satisfaction, as opposed to a judgment where someone wins the appeal and someone loses the appeal. It allows for more creativity, and therefore it is better for the parties ultimately, because they can actually design the settlement that they want. Finally, it allows for certainty of outcome of the appeal, because, like we have said before, it is party driven, so you may have a better control over the outcome, because really when you come before us sitting as a panel, many things can happen. You can win the appeal, yes, but it is also possible that you may lose the appeal. It is also possible that the appeal may be remanded back to the trial court for retrial. And therefore, you have a much more convoluted outcome, which if you yourself took control, you could avoid. Now, what is the case for appellate mediation? I think really this should speak for itself. The average time for a disposal of the of an appeal at the Court of Appeal today, given the workload, given the number of judicial officers available to deal with it, is an average of 4 years. So those of you who file appeals, you need to take that into account. It will also therefore add to the time that you have been at the High Court. And I don't know how long that matter may have been at the High Court. Perhaps let us say hypothetically another 4 years. So you are doing 8 to 10 years in litigation before you have a final result. So the use of appellate mediation ideally should reduce on the workload and the backlog that is in the Court of Appeal. Our current workload is about 8,000 matters today. And that will put the Court of Appeal with the heaviest workload in the judiciary of Uganda. At best, we can do perhaps now with a few more justices, a maximum of 3 panels if you're lucky. But the best we can normally do is about 2 panels. And therefore, you can see that even the ratio of, if a panel was equal to a judicial officer, is 2 justices of appeal to about 8,000 matters. The ratio is totally unrealistic in terms of quick justice delivery. But that is a systemic issue, which is for another discussion. But this is where appellate mediation can help. It is more flexible as it allows parties to focus on substantive justice without getting into technicalities, and therefore supports Article 126(2)(e) of the Ugandan Constitution. It saves time and money. How does it do that? By improving efficiency of dispute resolution. I think we have gone through that. It provides for greater level of confidentiality than would be in open court. And I think this is very important because the record of appellate mediation is not a public record. And therefore, you have the confidence to speak even off the record and say things that you would not be willing to say if you are at trial. Of course, therefore, the outcome does not create precedent. So when you resolve it, you have resolved it. There will be no further appeal to the Supreme Court. And that's the certainty that I've been talking about. And it, of course, will concentrate on common interests and common values as opposed to rights. And therefore, it allows the people in dispute to really go to the underlying issues within the disputes. Many times we sit in cases or we sit in appeals, and you can tell that there is a story which is not being told to you. There is some underlying issue, but the way the case is designed is to hide it from you because you feel that it will prejudice the case. But if it is understood, it may actually help resolve the dispute. So appellate mediation gives you that forum. So how does it work? we have very limited legal framework, but that's not to say that it does not exist. The Constitution in Article 126 provides that in adjudicating civil and criminal matters, courts should apply the principles that justice should not be delayed. There should be reconciliation between the parties, and substantive justice should be administered without undue regard to technicalities. Now, one of our problems is that most of the procedural rules, I know the Court of Appeal rules were made in 2000, but it must be remembered that the Court of Appeal rules of 2000 were cloned off the East African Court of Appeal rules of 1967. Yeah. So the point which I want to make here is that most of our procedural rules predate the constitutional demands that I have just read. So there is a need to sync them with the grand norm. And that is why we don't have many of our procedural rules onboarding ADR. The process is on. Order 12 has come for the civil procedure rules, but there is a lot more that has to be done to fully onboard ADR. So for that reason, the Court of Appeal rules do not provide for appellate mediation, but we have to read the current legislation in conformity with the constitutional framework, and therefore understand that really these rules are handmaidens of justice, so we should apply them in conformity with what the Constitution directs. And the cases of Kivumbi Dule and Honorable Emmanuel Pinto and Utex Industries and Attorney General, these are instructive in how to use the existing rules to reach a just result. So I have already referred you to Rule 22 of the Court of Appeal rules, which gives the inherent power. So that is a very powerful rule in working around the legal framework for appellate mediation. But the main rule which is being used is Rule 94. And I'll take you through it. But before I take you through it, I want to say upfront that there are two tracks that you may use for appellate mediation. Track one is before an appeal is called for hearing. And that's where we're going to start. Track two is when the appeal has been called for hearing. Both of them have different ways in which a final result may be achieved. So I want to start with track one, which is under Rule 94. And this is before an appeal is called for hearing. It is significant because this is the best track, because the mediation can be done before a justice or a registrar. Right now at the Court of Appeal, we have two justices assigned to appellate mediation. There is myself and Lady Justice Eva Luswata. where the justices who are managing this. So Rule 94 says an appellant at any time after instituting his or her appeal in the court and before, and that's those are the operative words, and before the appeal is called on for hearing, may lodge in the registry a notice in writing that he or she does not intend to further prosecute the appeal. 94.3 then says that if all the parties to appeal consent to the withdrawal of the appeal, the appellant may lodge in the appropriate registry the documents or documents signifying the consent of the parties. So the procedure key to appellate mediation is withdraw under 94. And this is what I think you should get familiar with. Now, before the appeal is called for hearing, several things may happen. The court itself can identify suitable appeals and encourage parties to settle. This is how we started appellate mediation. We just simply went through the files and identified those which we thought were suitable, and then we notified the parties. This is how we started, but increasingly, that is not what is happening. Secondly, parties can write to the court indicating their willingness to settle. Now, this is what is growing. Whereas at the beginning, we were encouraging parties, now parties are writing to the court and saying, look, we have reviewed our positions, both the appellant and the respondent, and would like to settle this appeal. So this is where the bulk of them are now coming from. The other, which is now also yielding quite a number of appeals for mediation, is at the time of scheduling. When the matter is being scheduled, then the parties may be encouraged or may tell the registrar that they want to mediate the matter. Now, of all of these three, the most efficient is when the parties write, because the parties then have control over the time. They can write even before scheduling. But if you wait for scheduling, it means that the dispute will just remain in the courts until scheduling takes place. And you must remember that scheduling in most civil matters will not take place until about probably 3 to 4 years after it has been set for, it has been filed, because that is roughly the time frame that we use. Now, when let's say the mediation is successful, what documentation are you supposed to deal with? The first documentation would be the notice of withdrawal. The notice will indicate that it is in full and final settlement of the appeal. That is to say that there is no further contention for the court to deal with. Secondly, it will say that the parties will bear their own costs. This is to avoid the application of sub-rule 4, where if the parties have agreed to settle the appeal, but they have not agreed on the costs, then the appeal will only be dismissed subject to a hearing on the matter of costs. Now, this is inefficient, and so we normally encourage that each party in writing out a consent withdrawal should concede that they have to bear their own costs. However, a way out of it is that if the parties still have issues with costs, but agree as to how those costs should be treated, then again, that would fall within the relevant provision of 94.1. And therefore, it can be struck out. Now, in addition to the withdrawal, many parties, and this is purely optional because it's not provided for expressly in the rules. They say the documentation, there's no clarity as to what the documentation is, but that reflects the consent. But we have evolved that to mean that the parties can, after signing the consent withdrawal notice, can attach a settlement agreement. This settlement agreement, not consent judgment like some of the lawyers write, it is a settlement agreement, will indicate the terms of settlement. For example, that hypothetical, if the damages and everything was supposed to be 100 million, the parties have agreed to settle at 70 and payment as follows. Or if it is redistribution of land, we have done quite a bit of that. We say that X takes this land, Y takes the other. We've done a lot of that in cases involving estates of deceased persons. What is the beauty about a settlement agreement is that it can then be used as estoppel by record or estoppel by accord if there is non-compliance or if further litigation arises therefrom. You're able to say, no, the other party is estopped by record or is estopped by accord because we have a notice of withdrawal and attached to it is a settlement agreement. That is the documentation. Very simple, not complex at all, very simple. Now, I'm going to talk about track 2. Track 2 is when the matter has been called for hearing, and the parties then at that point decide that they want to settle. This is more procedural because you would have appeared before a panel, and the panel may have taken arguments. The panel may even have adjourned for judgment. So in such a situation, you require the leave of court. So a good authority on this one would be this matter that I handled as a mediator. But because the matter had been called for hearing, after the mediation was successful, I then told the parties that they would have to return to the panel to seek leave for the case to be withdrawn. Jetha Brothers versus Mbarara Council and 4 others, Civil Appeal number 111 of 2013. Of course, the best time to do this is the moment that the appeal has been called for hearing. Because as you know, nowadays hearings of appeals take a very short time at the Court of Appeal. Hearing of an appeal on a regular basis, perhaps not more than 15 minutes. So it's better to come up front. Of course, if the matter has been reserved for judgment, and then you decide that you want to have the matter settled, then you have to move court. Say, look, we have settled it, we seek leave to withdraw the appeal. You cannot do it without leave of court. Now, what is the scope that we have seen? We have seen everything. We have seen all types of civil matters. We have seen all types of land matters, family disputes, taxation involving the Uganda Revenue Authority, election petitions. We have seen all of these under those 2 tracks. The parties we have seen are the usual appellants and respondents, but we have seen also settlements involving the Office of the Attorney General. Now, when you see the Office of the Attorney General putting a stamp of approval to this process, then you know that even government is willing to participate in appellate mediation. They find value in it. So we have settled matters involving the Attorney General. We have settled matters involving the Uganda Revenue Authority. The Uganda Revenue Authority has signed out quite a number of appellate mediations, again showing that taxation, regardless of the decision that was made at the trial court, they can still have a negotiation with the taxpayer to come out with a result that is a win-win for everybody. We have done countless mediations involving local government. Jester Brothers, the case I have cited, is an example. Now, to give you a sense of our statistics for the calendar year ended 31st December 2021, 100 appeals were handled, 53 of them were successful, 40 failed. This represents a 53% success rate. For the year 2022, we had roughly another 100 appeals, of which 62 were successful, and again, roughly 40 failed, which shows an increased success rate of 62%. And we believe that this is going to improve as people get more and more familiar with appellate mediation. So what is the future? The future is that we believe and we are preparing for the making of rules for appellate mediation to streamline the process. And I hope we can have a dialogue with Uganda Law Society as to the particular rules that we hope to bring in. We are increasing the number of appeals which are being mediated, and these are, we are seeing more and more requests. And so this is an area which I hope you who are on this seminar can internalize and even engage your fellow members to think about. I think the more exciting thing for me is that when we stabilize appellate mediation in the Court of Appeal, because this is the only place it takes place, we shall roll it out to high courts sitting on appeals from magistrates' courts and also to the Supreme Court. I say this because I know that when Justice Eva Luswata was in Jinja, she had consulted with us in the Court of Appeal and had started her own flavor of appellate mediation while she was resident judge in Jinja. And it was starting to get good results. So we believe that we can study this a little further and also onboard it for other high court divisions and circuits, and also the Supreme Court. And we envisage, certainly as the numbers come up, it will not be possible for just judicial officers to get involved. We may have to model on the trial mediation, where we have court-accredited mediators also coming on board to help with appellate mediation. I really like to thank those who have been involved in this, and it has helped us to do quite a bit of things. A few before I really finish this, a few points that I would like to say in terms of challenges. One, we're seeing a lot of litigation mentality, which is what I started with. And I hope that we shall be able to reduce on litigation mentality. The other one is overconfidence with regard to the cases that are on appeal. Say, I have won the appeal, I will not mediate. But you, as I've told you, you can never guarantee that you'll also win on appeal. Three, I think we need to up the legal advising in this area. We need to up the ability for counsel to engage constructively in appellate mediation and tell their clients that they have done an audit of the appeal, and it might be better in terms of time, in terms of money, to do a settlement now than have a win in the future or lose everything and start again. I think these are important areas which we need to think about as we get into more and more of appellate mediation. I think that is what I would like to say, and thank you especially to those of you who have been very instrumental in helping us to develop appellate mediation at the Court of Appeal. Thank you.
Thank you, my lord. Thank you so much for that comprehensive presentation about appellate mediation. Colleagues, a round of virtual applause. Can we just see your hands to thank His Lordship for that very well presented discussion on appellate mediation? My lord, thank you so much once again. And probably for me, when I first heard about appellate mediation, it was a breath of fresh air, knowing that, you know, after probably the 5 to 10 years in the High Court, and then again, Court of Appeal, you have another 4 to 5 years, that there was a chance for parties to sit down and talk. And we've seen that sometimes the clients themselves get litigation fatigue. They're looking for a solution. Probably the winner expects to benefit from the fruits of their judgment, but there's an appeal going on. Or the loser is also tired of continuous court. And that's the thing that clients have liked about appellate mediation, that finally we can end this psychological stress of court and litigation. So thank you for having spearheaded that innovation in the Court of Appeal. And thank you for sharing the statistics. I want to believe that my colleagues online can see that there's a hope and a future in us pursuing appellate mediation to ensure that we can give solutions to our clients. So at this point in time, I'm going to ask my colleagues to raise their hands so that they can ask questions if they have any questions for you, or if you don't have any questions, could you comment? Could you appreciate, my lord, so that then we can continue with the sharing. So I now leave it to you, colleagues. Could you raise your hands and ask questions? Okay, right now I see Cynthia Kwendo. You have a question. Unmute Cynthia so that she can ask her question. Cynthia, you can ask your question. Cynthia, unmute and ask. As we wait for Cynthia, any other member with a question, with a contribution, with an experience, if you've participated in appellate mediation, what can you share about it? Whether good or a challenge that we can all look into and find solutions to. Okay, I don't seem to see any hands up. Okay.
Olivia?
Yes, Cynthia.
My name is just His Lordship for the fruitful discussion. And thank you so much, Your Lordship.
Thank you, Cynthia. Colleagues, it's your turn now to share experiences, to appreciate His Lordship, to share any challenges you've encountered during the process. Okay, my lord, I guess as members think through, I think there's a time I was making a presentation at one of the ULS trainings about appellate mediation, and a colleague shared a challenge where he said that they had undergone mediation, and then when they appeared before the panel declined to endorse their settlement, and instead the panel insisted that they must hear the appeal on merits. And at that point, the colleague expressed frustration and felt like appellate mediation wasn't working if the justices themselves were not taking on a process that is within the very court. I don't know, my lord, what is the status now? Is it embraced by all the justices of appeal, and that when parties appear, then the court recognizes? How has that been addressed? So that's one of the questions probably you'll answer. Then let me ask Nora Matovu. Nora Matovu has her hand up. Admin, unmute Nora Matovu. Nora, proceed.
Hello. Yes, hello. Good morning. Can you hear me?
Yes, I can hear you, Nora.
How are you?
Fine, thank you. How are you?
Thank you for the session, and my lord, I appreciate the time that you have invested in this process. My comment is that I have noticed very serious reluctance on the parties to actually come up with a mediation, especially matters relating to land. Even where the judgment is very clear, there is no opportunity of that judgment being upset through the appeal process. You explain it to counsel, and you just don't get the results. Is there a way in which the Court of Appeal can organize maybe with the council, and we really look at this aspect? Because a lot of land is caught up in disputes and waste a lot of time and money going back and forth when the result still ends up upholding that same judgment. Back to you, moderator.
Thank you, Nora. Thank you for your question. I trust that my lord has taken note of that. Then we have Ndahilire Innocent. Ndahilire Innocent, please, you can ask your question.
Thank you, moderator. Thank you very much, my lord, for that very insightful presentation and sharing, which I must admit is so informing and knowledge enriching. I just have two questions. One is your view on why this approach is increasingly not being picked up in our profession. Some people have said that it's more or less like reducing our work, our business, just as counsel and as well as the judges. But its advantages really, one can't emphasize them enough. And it's also an area I think we'll need to increasingly really sensitize and inform the public, because the public is largely not really informed about this. So this is very good. It would be good to continuously sensitize on it and also share these kinds of advantages relating to it. The other question regards mainly actually on the criminal element. The other day when I was reading in the newspaper, and DPP, they quoted the DPP, office of the DPP, saying that they were turning down a mediation kind of approach of some case, even when the parties were interested. And it's also something we continuously see, that in criminal matters, mediation or dialogue is highly discouraged. Is that right? Or is that the approach, especially in view of the Article 126, clause D on reconciliation between parties, the need to promote that? In criminal areas, I think we're increasingly seeing this being suppressed, and probably with the view that maybe the victim or the complainant has been compromised. I thank you very much once again, my lord.
Thank you, Innocent. My lord, over to you for those round of questions.
Okay. The first question I think came from you, where I think you said you had an experience of a panel refusing to do an endorsement of a withdrawal. We really, I think there was some original problem with regard to tracking. That's why I have said you must be clear which track you're using for appellate mediation. There are some litigants who were using track 2 and trying to withdraw without leave of court. And so now we have made it very clear, and I think the registrars are on top of this. They are saying that please ensure that if you're in track 1, you have more control. If you're in track 2, you need the leave of court. The court has been endorsing quite a number of track 2s now because they have been properly structured, they have been properly implemented, and therefore there is no reason for the court to spend any more time deliberating and writing a judgment which is academic when the parties have agreed. And of course, this gives a lot of relief to the court, where the parties themselves have found a solution. So I think we're seeing more and more endorsements, but I must say that the bulk of the settlements that we're seeing as a result of track 1, where the parties seek mediation before the matter is called for hearing. At the beginning, there was that level of lack of understanding, but now it is quite clear. So I think that is the experience that you must have had. Madam Nora, in terms of the problems with land, land, of course, is the bulk of our business in the courts. The land disputes are everywhere. This is the wealth that Ugandans have, and they'll fight for it jealously. We're not a very developed economy where people now invest in shares, invest in stocks and bonds. Everybody wants to invest in land. And so I think as the economy grows, this problem will start to shrink. In many other countries, land is not really an investment as such. It is just a tool of production. We need to move towards that. So I hope we shall achieve that. But in terms of how we have managed it in appellate mediation, we have got some very amazing results. We have got decisions where the trial court has said that the land demarcations are like this, and you must accept them. Then they come on appeal, and now that people understand each other better, you may find that the winning party decides to give concessions and says, for peace, I'll just add you half an acre. Let us adjust like this, and we sign out, and everybody closes the matter, and it is done. It is finished. We have had a case involving distribution of an estate out of a family in Masaka, where one child was unhappy with the distribution of the property given to her, and adjustments were made, even if the will said something else, and the family was happy. What we're going to do, we're going to soon start a bar bench, court users committee, and we shall try and have more and more dialogues to see how these issues can be handled at the Court of Appeal level. I think the Court of Appeal level has one advantage over the trial courts, in that I think the trial courts may have given out what the landscape of the rights are legally. then it is up to the parties to determine, do they wish to stick with that, or do they wish to make concessions now that everybody knows where everybody is? And we're seeing a lot of that. We're also seeing it in monetary decisions where people have X amount of money, and that's the reason why the appeal is there, because they feel it is too much, and then concessions are made for early payments, and the matters get out of the courts. So I think yes, there is reluctance, but that's why I also think that not all resolution to disputes are legal. Some of them require good sense, wisdom. They require deeper understanding of the parties who are in court. For example, why we were able to resolve the issue involving the estate in Masaka is that the parties were able to tell us how the family dynamics were, which was not possible during trial. Nobody was willing to give that kind of evidence on oath. So when it was clear what the family dynamics were to us, it was easier for us to advise them and guide them into a settlement. That's where appellate mediation has an advantage, because you are able to go underneath the dispute and have a better understanding of what the dispute is about, and therefore you can help the parties better. Innocent, you're saying that you're wondering why this is not being picked up, and yet it is a very good innovation. Again, sensitization, I think seminars like this, what I was told by one lawyer is if they didn't teach it at law school, then it is not correct. So this is one of the problems. We need to start thinking outside the box. We need to not just do law, but we need to also do applied law, like we used to do in school. You had physics and then applied physics. We need to move to that area where we have applied law, because you're looking at the real world. You're looking at what are the interests of parties. Many of these disputes that come to us are heavily emotive. People have undergone pain. And, for us judges, we don't have sections or rules which help you with pain that you have suffered. Even if we give you money for pain and suffering, it may not resolve the hurt that you have. So really, at the end of the day, and we have had cases like that. We had a domestic mediation, and all that it required was acknowledgement. One of the spouses just wanted acknowledgement from the other spouse, and when that acknowledgement came, the battle just dissolved completely. It went away. 9 years in court, and all that was required was acknowledgement. But it was 9 years in the courts. The lawyers missed it. The judges in the trial court missed it. It was only through focusing on appellate mediation that this pain was resolved through a process of acknowledgement. When acknowledgement was done, even the rights that the spouse had got at the trial level, she gave up completely. She gave up. She said, "That's all I wanted." So how do you manage that? We have cases. Recently, we concluded an appellate mediation where the lawyers refused to sign on. They wanted to continue in court, so the parties signed. And the lawyers then came afterwards complaining that the parties had signed without their agreement. And we wondered who owned the appeal. Is it the lawyers or is it the parties? The parties said, for us, we have agreed, but the lawyers are fighting. And of course, you know what they were fighting about. They were fighting about costs. So for us, we withdrew the appeal. And they say that you deal with your clients in terms of costs, because for them they've got out of the court. So we must, yes, are these innovations designed to reduce the work of lawyers? No. They are designed to improve the efficiency and effectiveness of dispute resolution. You see, we must get out of the mindset that for you to have work at the bar means that you must be in court for 20 years. No. We must go into the turnover system where you resolve more, you get more. Because really, we could not understand why the lawyers were upset with their clients, because they had settled. The dispute belonged to the clients. In terms of criminal law, and this is not where appellate mediation is, but I understand where you're coming from. I think sometimes we must be careful about reading case notes, because I think I read that case note. I think it's important to read the full judgment itself. I think the important point is that they were flagging the powers of the DPP under the Constitution, that he shall not be subject to, he or she shall not be subject to direction by any person or authority. I think that is what that decision is about. So I think when you have that in mind, it does not mean that the parties cannot reconcile, because the DPP cannot force. I remember many years back managing a matter in Masaka, and the girl who had been the subject of defilement simply said that, for me, I'm 21, and she kept quiet. That was it. So that I'm an adult. If for the DPP to work, needs the cooperation of the stakeholders in that particular crime, and I must say that in spite of the way that judgment or that case note has been flagged around, the DPP has really done more disposals using plea bargaining than trial. They have signed out many plea bargaining agreements, which means that they are on to reconciliation. Yes, I think that is happening, and I think more innovations are coming in the area of criminal law. Diversions are on their way. Community acknowledgements are coming on their way. There are many things that are happening around the world that are changing the landscape of criminal law, so that if it is possible, not everything that happens should go through the court system. Of course, there are those where the crimes are very horrible, and it's not even perceivable that anybody would say this one should not go for trial. Those will continue. Those will continue. The decision of incorporating or taking cognizance of Matoput, the Justice Stephen Mubiru decision, where he as a mitigating factor is a great landscape. You know, we're now starting to bring on board also our traditional justice systems as mitigating factors. So I think the future is going to be quite interesting in this area of reconciliation and alternative dispute resolution in criminal law. Thank you.
Thank you, my Lord, and thank you indeed for opening up our minds that as lawyers, we don't have to only look at what we were taught in law school, but we should be more client-centric in terms of what do the parties need to achieve justice. And some of those concessions at the appellate mediations lead to that. And good to give us an example that some of the clients even went ahead to sign without their lawyers. So colleagues, we can run out of business if we frustrate what the party's interest is and insist. Otherwise, the parties leave us alone and the courts will endorse their agreement. My Lord, we have a couple of more questions. Some of the colleagues are saying, thank you. I believe you're able to access the chat, so I won't go through the appreciations. Let me go straight to the questions. Paul Kasami has asked, after thanking you, that how do we guard against the likelihood of appellate mediation being abused by unsuccessful parties to derail the successful party from realizing the fruits of judgment? I guess here probably the question is, are there timelines in terms of how long the process should take, such that in the event that then there is no hope of settlement, then parties can go and argue their appeal on merits? And the other is, how do we go about mediation of cases arising from highly specialized areas of legal practice, such as insolvency, computer misuse, banking and finance, and some other areas of practice? How do we go about them to avoid distorting the legal landscape? I guess if I'm just to broaden that question is, can parties change the legal pronouncements? I think that's something that should be clear. If the court found one fraudulent, can you consent to upset that? What are the limits of parties in their appellate mediation in terms of, and what the court can accept as a consent arising from the appellate mediation? And then Cheyago Edward asked, how do we handle the issue of mind change of litigants? I think you've talked about it briefly, and I hope colleagues can also share a bit. The question is, how do we then have a mindset change of litigants or lawyers, so to speak, regarding appellate mediation? Let me let you answer that round of questions, and then I'll bring the last round of questions before, my Lord, we close your session. Thank you.
Yes, Mr. Kasami is talking about abuse. Like all consents, they are based on good faith. They are based on good faith. So if you enter into a consent with bad faith, then it becomes problematic. But you see, this is where the lawyer needs to be on top of the game. And that is why we have started accepting what we call consent agreements. First of all, every document that comes in terms of a consent, whether it is done before a registrar, whether the consent is done before a registrar, or let me say, for example, if it is done before a registrar, the registrar will always bring that consent to either myself or Justice Eva Luswata, just to do a quality check on it. If there are questions, we will then send it back. So that is the first thing that we do. We do an audit check. You don't just file and walk away. We have refused some of the drafting, and we have asked them to improve, and many of them come back. I can't recall one which has not come back. We say that no, the way you have drafted here is not correct. Redraft. So, for example, you cannot on appellate mediation write a consent agreement saying that I have decided that, unlike what the judge said at the High Court, that I am not fraudulent or the person is not fraudulent. Appellate mediation does not remove the decision of the High Court. The High Court decision remains on record. What happens in the Court of Appeal is how you apply that High Court decision. That is what changes, but the decision remains there. So we try to mitigate possibilities of abuse, but if it is done in bad faith, we are not in the minds of people. It is very difficult to manage that. But remember, there is always a judgment in place. So therefore, I have found that the levels of bad faith, for example, in terms of setting aside, we have never, out of all the work we have done, we have never had a leapfrog to the Supreme Court, for example. That has not happened. We have not had some form of application coming to us telling us that something was done, whereas the truth was different. That one we have not had. And when we start, we are always very clear that this is a good faith process, and the lawyers and the parties are made aware of this. So our time is, by the way, quite limited. We are quite strict in the way we manage this process, and very clearly, if there's bad faith, it is seen, and the mediation shall fail, and it will go on to trial. The important point is, have the parties designed a way out of the court? That is the most important thing, in spite of a judgment. In specialized areas, we're also getting this. We have had consents in these specialized areas as well. Remember, and this is conceptual, mediation does not create precedent. Mediation only resolves a dispute between two parties. Parties, I can assure you 100% the time I have been a lawyer, been in judicial practice, parties are not interested in precedent. They're interested in resolution. It is perhaps lawyers, law students, and academia who are interested in precedent. The parties, they are not. They really don't care what the precedent says. As long as it resolves their dispute, they can continue with their lives. And they open up the money that has been locked in dispute with a bank. The loan is restructured. We've had so many loan restructures using appellate mediation. So many, the money that has been locked up, securities that have been tied down in mortgages, they have been released. You know, land that has been locked in dispute for years. We recently resolved a businessman's family dispute, a dispute involving a family of a businessman who had about 4 wives and about 30 children, and the estate had wasted completely. But we had each one of them sign a settlement agreement, and the estate has been revived. The estate has been revived. The solution there was very simple. All that was agreed is that the parties set up a company to run the estate, and these people become shareholders. And you have professional management to run the estate. And 11 plus years of dispute came to an end. So we must distinguish dispute resolution from precedent. And we used to have this problem with the banks. The banks used to say that if we settle, it will create moral hazard in the banking industry. And so they were very unhappy in settling loan defaults. But today, they're one of the leaders in doing this. Uganda Revenue Authority, they used to say you could not negotiate a tax assessment. And now things have changed. So where there is need for precedent, that will be done by the courts. Where there is need for settlement, that one is also available. We believe in a multi-door courthouse, which allows resolution through all means, whether through a court decision, whether through settlement. We are a multi-door courthouse. Yes. Now, Edward is talking about mind change. Mind change is a very big problem. This is change management is a big problem. Not only at the bar, also at the bench. We also have issues of mindset change. I remember when we were starting ICMIS, there was a lot of fear that jobs were going to be lost. Jobs are going to be lost. This technology is going to put us on the streets. But what we are seeing with the onboarding of ICMIS is staff are retooling. Staff are retooling. And now we have, I think if you go in many of our registries, many of the people who are running the registries are your colleagues. They are actually people with LLBs. Others have changed. Many of our secretaries have now learned to become transcribers. You see, they are now into that space. You need to retool. The same thing with the law firms. It is need to adjust. I always tell people that be wary of the legal future. You know, the AI is coming. You know, and you may be very comfortable where you are as a lawyer, but the legal landscape is also going to change within our lifetime. So they say that the one constant that they never told you at the Harvard Law Business School is change. You must be ready for it.
For sharing those vivid examples, and especially the ones to encourage us to think out of the box. I'm impressed about that estate that you resolved, where the stakeholders had to agree to forming a company to run the estate. I think those are some of the solutions we need to be thinking outside the ordinary to enable our clients come to a resolution of their disputes. Now, I'll ask you the final round of questions because our time is kind of spent up. This comes from Mr. Marse, who's appreciating, Moses Marse, who appreciates, my lord, your fantastic presentation. One of the questions is he would like to know why there are no rules after this stage and how soon these are likely to come out. I know that in your presentation, you touched on it. You mentioned about rules, you know, how you would like to partner with society, but probably you want to shed some more light on that. And then he also asks, is there any advantage in publishing the outcomes of appellate mediation in order to encourage increased participation and appreciation of appellate mediation by litigants and counsel? So that's a question from Mr. Marse. And then among the participants, someone had put up their hand. Just a minute, my lord. I think it was Otim. Just a minute as I look through the list. Okay, Geoffrey Otim has a question. So Geoffrey, please ask your question. They are unmuting you right now. Good morning.
I had just posted it on the chat, but I will ask it nonetheless. Now, Your Lordship, thank you for the well-articulated presentation. I am excited to hear the things you're saying. Quite rightly, you pointed out earlier that one of the challenges to the process is the overconfidence of the lawyers in the process of litigation, which can't always guarantee you success. My question is this: in the near future, can we, for instance, expect a situation where the parties can agree as part of an evaluative mediation process to ask for an opinion of a judge on a matter? Because sometimes the sticking issue in the mediation can be one party expecting or thinking a certain way in respect of a certain issue. And if an opinion can be secured from a judge, it may go a long way in helping the parties to reach a settlement. Can we expect in the near future such creativity and judicial and progress from yourselves to help the parties foster mediation? Thank you.
My lord, those are the questions.
Okay, the first set, I think, from Mr. Mate, the rules are coming. So let's just be patient on that one. Actually, the rules committee of the principal judge is working on fresh rules for the Court of Appeal. So it's going to be a holistic amendment to the Court of Appeal rule directions. So that one is in the offing. And certainly appellate mediation will be streamlined through that process, because right now it is not. We're using a lot of inherent power. Publishing the outcome of mediation, that one we cannot do. It is not regarded as ethical. But what we shall be able to do is provide you with statistics and examples of where it has worked, just like I have done. That one we shall continue to put out, and I hope that they will form a basis to encourage greater participation in appellate mediation. Mr. Geoffrey Otim, it's actually good to hear from you after a long time. You raised the issue of overconfidence. Yes, that is a challenge. But of course, the other thing is, especially at the trial level, most of the mediation is not evaluative. You see, so you can actually apply. You can actually apply under the 2013 rules for evaluative mediation. That is available. I have not seen much of it taking place myself. So I think it's a knowledge gap area. So evaluative mediation is also available. But now another area which I think the bar can start looking at is there are quite a number of ADR practices which are coming up involving retired justices and judges of the courts of judicature. That is also an area where people can go and see someone who has a judicial background, what is their opinion. That is now becoming available. In the US, there is a process, it has a horrible name. It is called rent a judge. That's what they do there. I don't like the reference to renting a judge, but I think this is a term of art that is used in the US, where they can go to a retired judge and say, look, what do you think about this? What is your opinion? And just as I end this one, in the corporate world, when you're giving a legal opinion, especially in many of these other countries, the first world countries, you're supposed to give an evaluation of your success rate. If we do this, success rate is 40%. If we do the other, it is 50%. If we do the other, it is 80%. This we don't do in Uganda. We just go to court. You in your heart, you know your chances of success are 0, but you have instructions, you will not pass on that information. I think we need to, again, deal with that mindset change and be more true to our calling as legal counsel, because it is a calling. You must always remember that the law came from the priest, the lawyers came from the priesthood. Thank you.
For your time, my Lord. Thank you for your nuggets of wisdom during this presentation. And thank you for opening up our minds to innovative thinking. I think rent a judge could be akin to expert evaluation or neutral evaluation in some jurisdictions. Probably will apply that here to avoid the rent a judge terminology, so that we can embrace the retired justices to kind of guide the parties in assessing their chances of success and probably considering resolution of the dispute at a much earlier stage, even before litigation. So, my Lord, thank you for your contributions on behalf of the Law Society. I'm giving you a standing ovation. I hope my colleagues can give you their virtual claps, but for me, I will give you a standing ovation, my Lord, because you have done us very well. We thank you so much for your time. We thank you for the presentation, that you could spare your time to prepare such a very well written presentation. We thank you for the dispute resolution staircase. I think we shall all be imagining it as we go through this process of resolving disputes. Thank you so much, my Lord, and we wish you a great day. God bless you. Thank you.
Thank you. It's been a pleasure. Have a great day. Thank you.
Thank you, my Lord. Colleagues, it's now time for our break. We'll take a 30 minutes break. So it's now 10:41. We'll be back at 11:10. I hope my mathematics is right. Let's come back at 11:10, and then we can continue with the session. Please go out and stretch. Take a cup of tea, water, a glass of water, juice, whatever is nearest, and let's be back to continue with the next presenters. Thank you. Dear colleagues, just allow me to clarify, since we are in a voluntary dispute resolution, I'm proposing that instead of a 30 minutes break, we could have probably 15 minutes break. I hope you can, by show of hands, vote to accept the change in the schedule. So if we can be here by latest back by 11. Let's get back here by 11 so that we can fast track our program and end by 1. Thank you.
Good morning, viewers. I'm Sandra Ainebiona, live from High Court in Kampala, where we have the Nagirinya murder case that is ongoing right now. In the last court session, the state prosecutors were ready to proceed with the witnesses, but the defense counsel requested for an adjournment so that he could study the witness cases. We are stay tuned with us so that you can get the live court session right now.
Good morning, colleagues. Once again, welcome back to session 2 of today's training. As I had introduced earlier, we have Mr. Julius Ojok, a partner of Ojok and Company Advocates, who's going to be one of our presenters presenting on court-annexed mediation. Earlier, we looked at a certain branch of court-annexed mediation, which is appellate mediation. So he will take us through the other branch of court-annexed mediation. And I trust, Julius, he will also briefly talk about private mediation as we discuss mediation. And then we'll also hear from Albert Mukasa, who's a partner at M&K Advocates. And he will take us through a brief overview of arbitration in Uganda. Obviously, arbitration is a very wide topic, but he will take us through pretty much some of it to just share how we view arbitration in Uganda and probably some few tips from the international spectrum on arbitration. So without further ado, I'll invite you, Julius Ojok. Come, Julius Ojok, and to talk to us. I know Justice Chiari already talked about mediation and what it means. Please share with us about court-annexed mediation, especially from your experience as a court-accredited mediator, what it means, and then other forms of dispute resolution that you know about and how different this kind of mediation is from those forms of ADR. Julius, over to you. Julius, can you hear me? Hello, Julius, are you there?
Yes,
Julius,
Olivia, I'm there. Can you hear me now? Hello?
Yes, Julius. Yes, Julius.
Can you hear me?
Now I can hear you.
Thank you very much. I'm trying to...
Just to avoid that we are not talking to a robot, are you able to briefly share your video so that our colleagues can ensure that
yes,
it's not a robot?
I'm trying to get my video on so that you can see it.
Okay.
Yes,
All
but
right,
you allow me to put it off as I connect the others.
Yeah, at least you're not a robot. That is certain. Thank you.
Thank you very much. Thank you very much for this opportunity, and thank you very much for Law Society for inviting me again to talk about this very important subject. It is always a pleasure and an honor to talk to colleagues and peers and talk about this mediation. It's not like addressing other people who are not in the profession. It's really quite different when you're addressing people who are in the profession. I have had the opportunity to listen to part of the presentation by Justice Kirabwire, or Justice K, as we fondly call him. And he has covered a lot of the areas, but nonetheless, I will just go through some of the pertinent issues that I feel it's appropriate for this audience. It's not the first time that I am making presentation on this matter to the profession. It's been over and over again. I think it's become a yearly event. And so some of the issues may appear repetitive for some, but I also see new names on the list of attendance. So I will go through them briefly, but I'll really emphasize some of the key important issues that I've learned over the past years that I feel they are of great importance to this audience. I will just start by looking at ADR. It's, of course, alternative dispute resolution. If you look at it, then it's alternative to what? Conceptually, we look at it as being alternative to litigation. So when we talk about alternative dispute resolution, we are talking about something which is not litigation. And Justice K again shared the ladder, how you get there. But some scholars have considered it to be appropriate dispute resolution. So if you find appropriate dispute resolution or alternative dispute resolution, sometimes they mean the same thing. And so what are these alternative dispute resolutions that we are looking at? Admin, if we could go to slide 4, you would find the various types of ADR, starting from consensual one to non-consensual one. When we start from the bottom, which is what parties usually agree upon, you start with negotiation. And that has been buttressed in our legal system with notice of intention to sue, which in most cases is abused by the professionals. Some write it, some don't write it. Others actually write it to instigate a suit. Not long ago, there was one which was a reply which was circulating on social media where one of the law firms decided to write back and say, go ahead and sue. And that was all. So again, that is meant to look at negotiation. We will look at negotiation in a bit detail when we look at the process of mediation. Then we have mediation itself, which we will look at it later. We also have conciliation, which is provided for in Chapter 4 of our laws. We have a mini trial. Now, a mini trial is conducted in such a way that if you have a big law firm or you're in a parastatal or an agency like URA, Attorney General's Chamber, you can set up a trial with the judge and lawyers, and you have the cases tried before you actually file it in court so that you evaluate your chances of success before you file a matter in court. If you find that the possibility of success is low, you can then have the matter settled. Then, of course, rent a judge, which Justice K talked about briefly. In this case, you just go to a retired judge and you pay him some money to have him resolve the dispute. This is still, again, not litigation. You are renting a judge in a private capacity to do the job. And then we have adjudication. This is mainly common in construction disputes. And finally, you have arbitration. I will not talk about arbitration because my colleague will talk about that in detail. So, Madam Moderator, these are the various forms that are available as ADR method. Maybe just to pick on the question that Geoffrey Otim asked, you have what we call hybrid processes, which is made up or up-made, meaning mediation, then arbitration, or arbitration, then mediation. I'll explain a little. When you talk of mediation, then arbitration, is that the parties can agree on most of the issues. And when that is done, then if there is a sticky issue that has not been agreed upon, it can then be referred to arbitration, and the arbitrator will decide on that. Or you can start the other way around. You agree to arbitrate, and when the arbitrator finds liability with one party, he can, for example, refer the issue of quantum of damages for mediation. And so, yes, in this case, the matter is not going before the judge, but it is still going before an arbitrator who can then make a binding decision, which decision can be implemented by the court. Yes, Madam Moderator.
Thank you. Before you take us through the mediation process, I just wanted to ask, in fact, you've used the term made, just to ask you something about medlit. I know we've had situations where in the courts itself, you find that parties reach partial consent. Maybe I'll ask you to briefly speak about medlit, mediation and litigation, but also there is where matters have been referred to referees or arbitrators within the provisions under the Judicature Act. I think it's under section 25 or 26 of the Judicature Act, where the courts, for example, refer matters to, let's say, an expert like an accountant or a surveyor, and then the parties, once they've gone through that process, then the decision that comes and the court finds it binding upon the parties and enters a judgment. Before we go into mediation in detail, could you just throw some light about that form of kind of intermediary between litigation and those two dispute resolution processes?
Thank you. Of course, I did not talk about expert evaluation, but it's also one of the ways in which you can resolve a dispute. The way an expert evaluation works is that the matter is referred to an expert in that area to evaluate the matter. And when they cannot reach a decision, and then the parties go by the decision of the expert. But also in some cases, they will still fail. Now, what happens is that, as Justice Case said, mediation is purely voluntary. So when you get a mediator and you agree on the points of disagreement, that becomes more or less the issues. And you are going to negotiate around that. And if you cannot agree on all the points, then that becomes a sticky issue. You then enter a partial consent agreement, which partial consent agreement is registered in court in that form, partial consent. And then the court will then go ahead and decide the issues that have not been agreed upon. Remember, we are talking about court-annexed mediation, where a matter is being mediated before it goes before a judge. And so if you fail to agree on some of the points, you can still refer it for the judge to decide on that point. That is still very okay. We also have in our CPA and CPR where the court can refer a matter for arbitration. I've had several matters referred to me as an arbitrator by the judges. They say, yes, the parties also provided for arbitration here. Before I hear this matter, let me refer it to an arbitrator. And therefore, I sit and hear the matter. And after concluding, because that matter has been referred by court, I then refer the parties back to court, either to resolve issues of cost or other things, or we can also conclusively agree to conclude it. The court may also refer it to, like you said, an auditor, if it is a financial issue to do with audit. They can also refer it to an engineer, if it is a contractual matter, and then they will look at it and then advise the court, which will then make the final decisions. I hope I've addressed the questions that you've asked, Madam Moderator.
Yes, you have, Julius, unless later in Q&A if people want some more information on that, but you've addressed. Now, I remember in law school, whenever we would start IAs, we would have to answer some questions by defining the concepts. So you've talked about mediation, but from the basics, what is a mediation? If one were to ask for a definition, what is mediation? Could you just...
I will refer you to slide 11, admin. And so for us to understand what mediation is, well, the 2013 rules define what a mediation is, where a neutral third party facilitates the discussion among the parties and assists them in reaching an amicable settlement. And so the keywords in the definition, which you have to look out for, is one, there must be a conflict or a dispute. In litigation, we talked about there's a matter, there is a case. In mediation, we talked about conflict, mainly. Mr. Mukasa will tell you that in arbitration, you talk about a dispute. Some scholars have tried to distinguish between disputes and conflict, but that is for another day. So there must be a conflict and there must be a neutral third party. Earlier, I talked about negotiation. Negotiation is between the parties. The plaintiff will approach the defendant and then they negotiate. In a mediation, there is a neutral third party. That's the mediator. Neutral meaning that is not biased towards any side. He is an independent third party who will come to facilitate the discussion between the parties. And then the role of the mediator is to facilitate the resolution of the dispute. There are so many things that hinder the resolution of dispute. There is communication, there is ego, there is balance of power. You find it's probably a bank against an employee of a very low cadre. In that way, it's not evenly balanced. And so the role of the mediator comes in to ensure that there is power balance in the negotiation and in the mediation. And finally, his work is to help the parties reach an amicable settlement that is agreeable to all the parties. You do not impose. Even if you are a judge or a magistrate conducting a mediation, you do not impose your views on the parties. It's the parties to reach a settlement. So in brief, that is really how we define mediation. Thank you.
Julius, and before I ask you about the types of mediation and probably the process, what is involved in the process, I just want you to just clarify. I've had situations in court where parties tell the judges or the justices that they need to go back and mediate. They ask for time to go for mediation. But when they go back, it's really the, let's say, the plaintiff defendant with their lawyers who meet, let's say, in a boardroom and have a conversation about the matter. What is that? Is that mediation? Just to clarify, where you have the parties and their lawyers, what does that amount to?
That amounts to a negotiation. In the absence of a third party, that amounts to a negotiation. So if the mediator is not there and the parties negotiate, talk among themselves, they are negotiating. They are dealing between the two parties. But if there is a mediator, then the process is called a mediation. So there is negotiation and there is mediation. Where there is no mediator, it's a negotiation. Where there is a mediator, it's a negotiation. Of course, some parties negotiate in the absence of the mediator, and then they later take it to the mediator to endorse, because this is a court-accredited mediation. You had earlier asked me to talk about private mediation. Now, private mediation is where it's not connected to court. And the outcome of private mediation is a mediation agreement, which becomes a contract for purposes of enforcement in court. It's not a judgment. But for the case of court-connected mediation, the outcome, if agreed, becomes a judgment of the court. Private mediation, the outcome is a mediation agreement, which becomes a contract between the parties, and you will sue like you're suing on any other ordinary contract if you have to enforce it. So those are the positions as I know them, Madam Mediator.
Thank you very much. I'm glad to become a mediator for this session. It's okay. So please take us through the different types of mediation and how one is able to determine which is which when they're exposed to one.
Okay. Thank you very much again. I'll take you through the various types, but you will realize that this is really academical. The division is really academical. As a trained mediator, you will juggle through most of these methods. So when you look at the divisions or the types of mediation, they are mainly categorized into three, which is facilitative. And when we are training court-annexed mediators who are not judicial officers, we advise them to use the facilitative mediation. The second one is the evaluative, and I'm glad that it was put to Justice K during his session by the audience. And the third is what we call the transformative mediation. I'll now go through one by one. What is the facilitative mediation? The facilitative mediation is the type of mediation where the mediator facilitates discussions and negotiations between the parties. All he does is to ensure that the parties are discussing or negotiating to handle the points of disagreement. By the time a conflict arises, it shows that the parties don't agree on a few things. And so your work as a mediator is to facilitate the discussion. In the case of court-annexed mediation, it's between the plaintiff and the defendant. So how do you negotiate? How do you help them to talk to each other to resolve such a conflict? Take, for example, a case of breach of contract. You did not make the supply as provided for in the contract. There you get the parties to talk about the breach and how they can remedy the breach. The beauty with mediation is that you get solutions that you would ordinarily not get in court. And so in a facilitative mediation, the mediator will look at the parties. Now, in handling that, as we shall see during the time for looking at negotiation, you look at interest, not positions. And I'll look at that shortly. So in facilitative, you are concerning yourself mainly at interest and not positions. While when we look at evaluative, which is the second type of mediation, evaluative comes from the word evaluate. And so when you are doing evaluative mediation, you look at the strengths and the weaknesses of the party's case. If it is the plaintiff, what is the strength of the plaintiff? And what is the weakness of the plaintiff's case? You look at for the defendant also that way. Now, when we are training judicial officers in mediation, because of their position, that is a method that is suitable for them because they have that authoritative positions which they occupy. But remember, even with evaluative mediation, it's still done within the precepts of mediation, and therefore the mediator has no powers to impose his views on the parties. So in evaluative mediation, you are looking at the party's position. Now here, you are free to look at the plaintiff and the defense, because that will give you the positions of the parties. Remember that in facilitative, I talked about interest and positions. But in facilitative, you concern yourself more with interest. But here you are looking at positions. So you can revisit position of the law and say, this is what the law says. In order for you to succeed in fraud, to cancel the title, you must look at fraud. So let's look at your case. If at all you meet those criteria. If you don't meet, then you can say, from my point of view, you don't meet. So you've evaluated the case. If the case is about somebody who has a certificate of title and the other one who doesn't have a certificate of title, you look at the RTA and you say, looking at the RTA, you are at a disadvantage to this person who has a certificate of title. So you evaluate the positions of the two parties when you are looking at evaluative mediation. Now, the last one, which is transformative, is about power imbalance in a mediation. I had a mediation where I had an MD of a bank appear before me, and it was a cleaner on the other side. And so you could see that the power imbalance was glaring. Sometimes for those of you who do family mediation, you may find an overbearing spouse against the other spouse, and that becomes a power imbalance. Sometimes even to the extent that one of the parties begin to cry before you. So in that way, there are two things that you have to do. The first one is to recognize the power imbalance in your mediation. And once you've done that, you then do try to uplift the other person. By saying that, I'm not saying that you shouldn't appear biased or on the side of the other person, but you encourage that person to speak up for herself or for himself in that mediation, so that there is a discussion between the two without any one side feeling much left out. So those are the three, but as I said earlier, they appear academical. Somebody conducting a facilitative mediation can also do an evaluative mediation when he's caucusing with the parties or doing private meetings with the parties. When you've separated the plaintiffs from the defendants, you can then analyze their case with them individually using the evaluative method. Also, you can apply the transformative mediation with any of these two. If one side is not up to the game, you try to transform the environment in the mediation room so that everybody can freely speak and negotiate. Remember, this is an agreement that is agreed between the parties. So if the parties cannot speak up, you may not be able to succeed with the mediation. So those are the three main types of mediation. But as I said, they are really used interchangeably depending on the scale of the particular mediator. Thank you.
Thank you, Julius. Now you've spoken about the three, but I have one question, especially regarding evaluative. I know what we are usually used to is that evaluative is conducted by judges. That's the mindset, and maybe because of the position and the respect that parties have. But my question for you is, how do you strike a balance? Remember, it's understood that a mediator should be neutral. So if you conduct evaluative mediation in the process, how do you ensure that the parties don't look at you as being, a bit biased because now you're trying to analyze and telling one party that, your case might be weak here or there? Isn't that, delving into the arena, how can you make the balance and ensure that the parties still look at you as a neutral mediator, even when you're conducting the evaluative mediation?
Like I said, anybody can do evaluative mediation. In this case, it is advisable, if you are not a judicial officer or if you did not adapt that style of mediation from the very beginning, is to do it during private meetings with the individual parties or during caucusing. That we will look at the process where you're allowed to talk to the plaintiffs in the absence of the defendant. So that is the way in which you do evaluative mediation. Like you rightly pointed out, the notion out there is that it is for the judges. No, it's not only for the judges, but if you have some in-depth knowledge about the subject matter, for example, if you're handling tax dispute, you can go into the nitty-gritty of tax and evaluate the position. On our list, you can have a surveyor who is doing a mediation, and therefore he can go into the nitty-gritty of surveying when it comes to a dispute. But remember, for a court-annexed mediator, I am under obligation not to disadvantage any party. I am also aware that there are lawyers who come for fishing expedition, and therefore I should not allow a party to bring out, or I should not do it myself in such a way that I am disadvantaging a party in the event that the mediation fails and they go for a trial, because I would have armed the other side. So it would be preferable that you do that evaluation if they have not decided it upfront, in the absence of the other party. That's when you can evaluate their case with them. Remember, you are also under obligation to keep confidential what you've discussed with one party in the absence of the other. So you as a mediator, having explained your role, you can then do an evaluative mediation with them in the absence of the other, so that you don't disadvantage another party in the event that the mediation fails and they have to go for litigation.
All right, so now I can see that for many of us on the call, we can, one, have a career of mediator. So in other words, some of this knowledge that you guys share, this knowledge that would apply if we're appointed mediators, but also if we're in a mediation room and somebody's conducting the mediation, it would be easy for us to identify the style that the mediator is applying. So, Julius, as we delve into the mediation process, sometimes we advise our clients, we have a mediation going, you know. So I think we'd want to know, when we are preparing our clients for the mediation, what we tell them about this process. Or if I'm the mediator and I'm preparing for mediation, what is that process that I must have in mind that I should run the parties through at the beginning, that this is what the process will be like when we go through the mediation? Could you just take us through the mediation process and what is involved in that process?
Thank you very much. I mean, you can go to slide 13. The mediation process involves two stages. The problem defining stage and the problem solving stage. So in order for you to resolve a conflict, you must understand the conflict. When you go to a physician, in order for you to give you a better prescription, he has got to interrogate what your sickness is. Is it malaria? Is it typhoid? Is it sugar level? Is it high blood pressure? And so he has to understand your sickness. It is only when he has understood, that is when he can now give you a proper prescription for your sickness. And so the same applies with mediation. You have to understand the conflict first, and then you help the parties resolve it. So the first stage is the problem defining stage, and the second one is the problem solving stage. In the problem defining stage, you have the preliminaries. The preliminaries is where you welcome the parties. After welcoming the parties, you give them a seat and you have them sit down. It is very critical because it informs how you are going to mediate. Those who are quite knowledgeable about mediation will be observing you, and some of the parties will also use it. Take, for example, if they see you are a Muslim and the parties are entering and a lady enters with a hijab, how you react is very critical. Where do you give her to sit is very critical. And so those are the preliminaries that you need to pay attention to. You are a Catholic and somebody walks in with a rosary hanging on his neck. That becomes very critical. Also in the preliminaries is how you introduce yourself. Introduction becomes very key. So for a mediator, you need to know the parties that you are dealing with, and you need to establish right from the introduction where these people have the authority to settle the matter which Justice K talked about. Take, for example, if it is a matter involving the bank, and you don't see the operations manager, you don't see the MD, you don't even see the branch manager, okay? Just assume that it is a teller who is before you. Certainly, you know there is a problem. So the preliminaries are very, very important for you as a mediator. And also that is for lawyers, you need to talk to them about. For those of you who would want to interest yourself in the career of mediation, you need also to introduce yourself well. What is it that you do? Where do you work? Which law firm? So that if there is any issue of biasness or past dealings, then you are able to leave the mediation at that stage, other than start the mediation and then reach the middle and then you get embarrassed. I had a law firm object to me and said, no, we will not want Julius to mediate this matter because he's also a tax practitioner at that time. So the matter went to the registrar of mediation, of course, but they said, no, he's just a mediator. He can continue to mediate the tax matters. So at the initial stage of the introduction, it's very important. We also had the review of Serena hotels. And those who acted as the accountants disagreed. I acted as the legal consultant for that review. And so the mediation came before me. And I had to introduce myself that I had worked with one of the partners in the accounting firm to do that work. So I couldn't actually, without that disclosure, go ahead to mediate. So they said, it's okay, you can mediate. So that is the first stage. You set the stage for the mediation. You have to ensure that the parties are comfortable. Where possible, you make sure that the sitting arrangement is proper. We do not have the facility in most of our courts, including the commercial court, but it would be advisable you get the parties to sit at a round table, but it's not possible. So you ensure that you're able to, at any one point, see the face of anybody in your room so that you pick out certain emotions. Now, the second process is the opening statement. The mediator will give his opening statement. He will talk briefly about himself. He will talk about the benefits of mediation. He will talk about the ground rules of mediation. And in most cases, if you find a good mediator, he will invite the parties to validate, especially the ground rules. Remember, it is very key to involve a person from the very beginning. If I'm just talking to somebody and they are not interested, they will keep away. So it's important that you do that at the point of the opening statement. Thereafter, the parties will give their opening statement, what they understand by the conflict. So now the parties will tell what is it that they understand. I had a situation where the parties came before me, and when it reached the time for the defendants, the lawyer just said, Mr. Mediator, they are the ones who sued us. So let them tell us why they have brought us to court and to this mediation. Now let's go into why you would make an opening statement, which to me is a more critical aspect than the opening statement itself. The first one, it gives you, the mediator, an impression of who you are, how serious you are. Remember, mediation is mandatory, at least before the Civil Procedure Amendment, which I still think it's being misconstrued. It is mandatory to attempt that, voluntary to reach a settlement. So at that point, the mediator can agree and say, I will not continue with this mediation. So one, you make an impression on the mediator when you are making your opening statement. You will be able to see how serious you are, how committed you are. Two, you are able to put across your views, your understanding of the case. Remember, even when you go to court, it's about your lawyers impressing the judge and persuading the judge. But there are various ways in which we can persuade people. The way we talk, the way we appear, and that is usually demonstrated in your opening statement. It is also an opportunity for you to put forward your demands in the negotiation. What is it that you want? What is your position? He has breached the contract, so I want to be compensated, or I want specific performance or something like that. So that is why opening statement becomes very important for the parties. Then after that is done, you then go ahead and reach the points of agreement, okay? Usually when we are doing litigation, we say agreed facts. So you look at the points that have been agreed. Now, let me say this. If you are going into a mediation or a negotiation, there is always what we call BANTNA, which is the best alternative to a negotiated agreement. So if your best alternative is to negotiate, then you make sure that you list as many points of agreement as possible. Because if we agree on many things, it is likely that we can resolve the few areas where we disagree. So you list the points of agreement. After you've done that, you list the points of disagreement. Where do the parties disagree? Others will say, yes, I supplied this. The other one will say, no, it's not the right quantity, or no, it's not the right quality. It was not supplied in time and all that. So once you've reached that point, you have fairly understood what the problem is. And in litigation, the points of disagreement would constitute the issues for resolutions. So the moment you've reached that, we believe that you would have fairly understood the problem. And therefore, you now go to the second stage, which is the problem-solving stage. Now, the problem-solving stage starts with the negotiation. You as a mediator, remember your work is facilitative. So you are saying, yes, plaintiff, what are you saying? What are you demanding? Defense, how do you respond to their demands? What do you say, defense? Plaintiff, how do you respond? In simple terms, negotiation is just bargaining. We bargain every day, and that is what you do. Now, if sensitive information is being divulged or the parties are not willing to move their positions, then you move them to separate meetings or private meetings or caucusing, although the politicians have now vulgarized the word caucusing. You put the plaintiffs different and you put the defendants different, and then you go through the available options. When you are negotiating, there are about 4 or 5 steps in principal negotiation. There is positional negotiation and there is principal negotiation. So in principal negotiation, one of the steps is to look at the available options. And when you are looking at the available options, you list as many options as possible. Then you begin to evaluate one at a time. There is a danger where people will say, no, that option is stupid, that one can't work. People are always quick to dismiss it. But as a skillful mediator or as a skillful lawyer listening to your team, you first list all of them without allowing people to ridicule some people's opinion. Then you go one by one, seeing what can work and what cannot work. So when you reach that decision in the separate agreement, you then call them back and they agree or disagree or partially agree and partially disagree. Thereafter, you take the final decision, whether the mediation is successful, whether it has failed, or whether it has partially succeeded. Now, as a mediator, you should avoid the problem of trying to look for better statistics that the mediation has succeeded, therefore you impose on the parties. No. If it has not, just say it has not. What I've learned from experience is that sometimes you help the parties walk through their case. They may not agree before you, but they will go out and agree and file a consent subsequently. Also, sometimes when we go to the next one, which is recording the agreement, if you take long to record the agreement, there is what we call the buyer's remorse. In that, I can go to this shop and find a suit of maybe 1 million. When I go to the next shop, the same suit is being sold at 700,000. So I feel like taking back that suit to the first shop. That's what we call a buyer's remorse. In mediation, what happens is that after reaching an agreement before the mediator, you go back and you find yourself stuck. People now giving you a lot of advices that you've done wrong. That becomes a problem. For those of you who may be involved in family mediation, you find that you have the spouses in front of you. They have reached an agreement. They go back and their parents are telling them that is not acceptable. Especially you have mothers-in-laws. So that becomes a problem. So what is advisable is that when they reach the settlement, in as much as possible, try to record it as soon as possible to avoid that thing of the buyer's remorse. Why would you record it as soon as possible? To avoid the parties changing their minds. Also, the lawyers, as Justice K mentioned, the issues of fees will come in. You will look at Rule 20, I think 20 or 22 of the mediation rules, which does not necessarily provide for costs unless agreed by the parties. So that becomes a stumbling block, and you may take many days without the consent being entered. After that, there is the closing remark. Remember, you are colleagues, you are lawyers, so even if the mediation has failed, just be courteous and allow the mediator to close the mediation and you move on. And so the final one will be closure. Thank you, Madam Moderator.
Yes, thank you for taking us through that prolonged process of mediation. And we know under the rules, we're usually given 60 days, and sometimes parties ask for more. So that means that all that is something that is done in those number of days. Now, there are parties involved in this mediation process. You mentioned lawyers, you mentioned the mediator, you mentioned the disputing parties or the conflicting parties. Could you take us through what each of those parties is expected to do, or what their roles are in those mediation proceedings?
Okay. In the mediation process, the most important person there is the mediator. The mediator has several roles that he has to play based on the type of mediation and the subject you are handling. My experience has shown me that given the type of mediations and the subject matter, you need to employ different techniques. Family mediation is highly emotive, and so you need to pay attention to the emotions. Unlike commercial mediation, where the parties are dealing on a subject of contract. Now, the contract might be a one-off, which is not the case for a family mediation where there are long-term relationships. And so the consideration have to be different. Starting with the mediator, your role is to set the ground rules very clearly, respect in the process, speaking one person at a time, not interfering with the other person, making sure that you keep time, you balance time. I had a mediation fail because one perceived that I had given more time to the other as opposed to the time that I have given him. So I usually now check with the parties, if I am the one mediating, that I've given a balanced time to all of them as a mediator. And so making sure that if it is a court-connected mediation, you do not also jeopardize the parties' chances when they go to court. Related to that is also to identify lawyers and parties who are on fishing expedition. And you can do that either by caucusing or by, in a humble way, telling counsel to stick to the rules of mediation, not to be fishing for his litigation. And so those are the key roles of the mediator, apart from ensuring those legal and statutory one of not being biased, not being neutral, taking the parties through the right process and being competent. Now, when it comes to the lawyers, my experience training mediators and dealing with them shows that there are those who want the lawyers to participate, and there are mediators who will say, no, this is not a lawyer's process. This is for the parties. I, for one, believe that lawyers play a very crucial role in mediation, and therefore any mediation should also involve them, because if you don't involve them, they can also sabotage the chances of success, because they'll go and tell the parties, don't accept. And the parties believe them more than they believe you, the mediator. So you have to ensure that you balance the role of the parties. So for the lawyers, they have to prepare the parties on how to negotiate. Unfortunately, many of us lawyers are not trained in the art of negotiation. How do you negotiate? All we know is positional negotiation, which is like bargaining for a special hire. Before we had Uber. You would say, I want to go to Kabalagala. The man would say, you bring 100,000. No, I don't have 100,000. I have 90,000. The man will say, no, I'm not accepting 90. I am accepting 130. So that is the kind of negotiation we are used to, but we don't look at the interest of the parties. If I am hiring this man to take me to Kabalagala, how much time do I have? Why am I going to Kabalagala? And if I reach there, how will I look when I disembark on a border or I disembark from a special hire? And so the lawyers have a role to look at their case, to evaluate the case. What is our best criteria? Justice K was talking about the workload. At the time, I was actively involved in the commercial court, and I think that was the time Justice K was there. Each judge had about 340 cases to handle. Now, as he said, that would take you roughly 3 to 4 years. Would you want to go there, or would you want to release that mortgage, have that asset free? So the lawyers must prepare the parties to negotiate. And also during the negotiation, they should be alive, not to allow their parties to disclose information that would jeopardize them in litigation, especially if the other one is fishing. So if, for example, I had a client who told me, Mr. Mediator, there was a bit of forgery here and there, and immediately there and there, we had to call off and go for caucusing. So the lawyers need to be alive to the process. But most importantly, they also don't have to disrupt. Some lawyers go and say, this is party's process, and they're either busy on their tab or on their phone, and it's a bit disruptive for those who will pay attention. So for me, that is what is really very important. Remember, you are a professional advisor in this process as a lawyer. For the parties, they have to first accept. It is not really a written criteria for mediation, but as Albert will tell you, for an arbitration, there has to be arbitration clause before a matter can be arbitrated. But for mediation, the parties have to agree. There's agreement to mediate. There's agreement on the venue and then how you conduct the process. It's a party-led agreement. Remember, the mediator is just a facilitator. Then the issue of confidentiality is very important. If I'm the one mediating, I tell you in my opening statement, if anything gets out of this room, then know that it's us who are in this room. And then the final one is the settlement, the agreement. It's very important that you have the parties agree on the terms of the settlement. If I am the lawyer who is involved in a mediation, I usually make sure that I use my own words on how to draft the settlements. Remember, the parties will say, okay, let them pay me 100 million. They are comfortable with that. But as a lawyer, you can come in and say, when should the payment be done? How should it be done? And you clearly stipulate who will do it so that it becomes something which is executable, not just a promise. So those are the key roles that I would identify for the mediator, for the lawyers, and for the parties. Thank you.
We come towards the close of your presentation. You've mentioned how you've been participating in a couple of mediations through the quarterlets. So I would like you to share with us the experience, of course, without divulging the parties due to confidentiality, in terms of benefits of mediation specifically. What have you found to be the benefits? And let's talk about that, address the concern of lawyers, the fact that they feel that mediation takes away their cow. If you close quickly, then you don't have a case for 5 years to continue to be okay. How do you balance that? How beneficial is it to lawyers to close cases at mediation rather than going through the entire length of litigation.
Thank you, Madam Mediator. I have had the benefit of not only being a mediator, but I also drafted the 2013 rules. So a lot went on. Yes, there are lawyers who believe that mediation is not proper because it takes away their food. There is no cost. But that belief over time has been changing, but it has not. We see that reflected in the amendment to the Civil Procedure 2019, where they now say, okay, the judicial officer will decide whether to refer the matter to mediation or not. So it's still there. But as somebody who drafted the 2013 rules and somebody who has been a mediator and somebody who usually also acts as a lawyer in a mediation, mediation is very important. One, it doesn't stop you from charging your fees. You can charge your fees, and usually, as a lawyer who has practiced nearly 2 decades, the curve is that you get your fees at the time the parties come to you. Towards the end, they would not want to pay you. So when you get that at the beginning, you involve in mediation. Within a short time, like the rule says, within 60 days, you conclude the file and you move on. Most of my cases are mediated cases. I try as much as possible not to get into the litigation. Not that I don't want to. I am able to go through the process, but it closes the deal better. Looking at people's businesses, they're able to continue with their businesses. We had one such case where the containers were detained in Mombasa, and we were here fighting in the commercial court about the containers. One of the parties said, I will not move the containers. Now the festive season was approaching, and these people needed the containers in Kampala so that they could sell it. And there was no way we could get, with that speed, that matter handled in the court. And so the best way to help the parties handle the matter was to go through a mediation. And that really helped us. The other thing is about flexibility. You have the flexibility to juggle. I'm not going to mention names of judges, but you know judges who will not bend the rules. They will say, but the rule says this, counsel. What do you say? I will dismiss your case. That doesn't apply in a mediation process. Part of it, you may get it in arbitration, but in a mediation, no. So you are flexible. The other most important thing is that you have control over your case. The mediator will use his authority during the mediation process, but he really doesn't have control over the case. It is you, counsel, together with the parties, you control what goes on in a mediation. And so for me, that's really very key. I will tell you that parties have gotten remedies which they would not get outside mediation. This is a case where these were performers and their contract was canceled because they did not have the capacity, and a South African performer was brought in. So when they sued for breach of contract, one of the remedies they reached was to be trained over time by this South African performer so that in time to come, they would be able to do it on their own. No court would grant that remedy to you in a litigation process. And lastly, as Justice K mentioned, is finality. You don't have appeals. This may not augur well for those lawyers. You remember those story in the law school where the son finished the case for the father and went back to the father very happy. Dad, I finished this case while you are away. And the dad said, you're very stupid. That's the case that paid your school fees. So for those type of lawyers, this may not help you. But for those who want to make money and move on to the next file, it's a final process. After you've been paid, the concern is entered, that's it. You move on to the next case. I think that's where the benefit of mediation is. And thank you very much, Madam Moderator.
Thank you, Julius. In fact, when you're speaking to benefits, I also thought about the psychological fatigue or mental fatigue, both to parties and lawyers regarding litigation. Sometimes clients think you're not doing much because of the case backlog. Cases are not moving, so you find the client even withdrawing instructions because they think as a lawyer you're not working. But also as a lawyer, if you had a case for 8 years, 6 years, and then you go on appeal, I mean, there's that mental fatigue over doing the same thing over and over again, adjournments and all that. And I found that when you settle, there is that peace. I don't know about others, but for me, I think I found that peace to be able to concentrate on other new matters that are coming up and devote attention to the other cases other than sticking on one case for 10, 20 years. By the time you get the judgment, probably even the client has lost interest, or some clients have passed on. So whatever you've been fighting for over the years doesn't really pay off for the client, and you kind of feel it. So beyond the physical things, I think there's also that mental fatigue that disrupts us as lawyers. And in this era of mental distress, I think we need to watch out for our own mental health as lawyers and see when we need to get to close cases so that we can have a peace of mind. Okay, now, Julius, as we close, what are the ethical considerations for mediators, but beyond mediators, even as counsel? Because I believe much as we don't have any specific ethical rules as lawyers to be sitting in that mediation room. For you as a practicing mediator, what would be those ethical considerations you believe to lawyers to ensure that the mediation process is fully respected and successful and can grow as it has in other jurisdictions?
Well, the greatest ethical consideration, as I said earlier, is neutrality, that you remain neutral during the entire process. The parties will try as much as possible to pull you to their side, try as much as possible to remain neutral, not to lean on the other side of the parties. So that, to me, it's the greatest consideration that a mediator should take into, you should take point of. The other one, which is easy to deal with, is impartiality. Ensure that you are not related to the parties. If it is a law firm, you've not acted for the parties before. You then, because sometimes it's your partners or former colleagues who come before you. I had one person object to me. This was in arbitration because I had Katende Sempebwa appear before me, and I did my clerkship in Katende Sempebwa. I had people come to me object because I worked with Sebalo and Lule, and they are saying, look, this matter is being mediated by Sebalo and Lule. So try as much as possible, if you have any historical dealings with the parties, make sure you are the first to disclose and you seek their approval. And if it's not granted, you leave the file and you move on. The other thing for lawyers, which you need to look at, is good faith. Avoid fishing expedition so that you go and prepare your cross-examination in a mediation process. And that blocks your mind to an amicable settlement. You then become focused on taking the matter for litigation. And yet when you focus on the mediation, you could resolve the matter and have the issues dealt with. Then also avoid legal counseling. If you are not the lawyer in that case. If you are a mediator, your work is not to provide legal counseling. Your work is only to ensure that the parties develop options. And there are various ways you can ensure that people come up with options without conducting legal counseling. And finally, ensure that what you are going to discuss and agree on are legally correct. Remember, the judge or the registrar will vet a consent settlement. And so if it's not vetted, if it's not legally correct, that becomes a very serious ethical issues on your part by including something that is not legally correct. So those are the few ethical considerations that I would encourage us colleagues to take into account when we are doing mediation. Thank you, Madam Moderator.
Thank you so much, Julius. Colleagues, a round of virtual applause for Julius for that comprehensive discussion on mediation. I'll just give only 5 minutes for question and answer. Thank you, colleagues, for those virtual hands. So I'll just get a few questions so that we can dive into arbitration and then make sure we are done by 1. So if there are any people that have questions regarding mediation, please put up your hands so that I give a minute or 2 to ask your questions. I'm not seeing any hands as yet. Okay, Natasha Ivan says, thank you, Julius, for the discussion. It would seem everybody understood everything. That's, I've not yet seen any hands up. So in light of that, once again, Julius, thank you very much for your time. I trust that you will share the slides so that the ULS can forward them to all the participants. Thank you so much for your sharing, but please stay on call just in case any question comes up when it's Albert presenting. So now, colleagues, allow me to let Albert take on the presentation on arbitration. Julius talked about arbitration, but he did not define it. He did not even go into some of the details. So I invite Albert Mukasa to take us through arbitration. It may not be comprehensive because arbitration is another wide practice area that cannot be covered in an hour, but this is going to give us the basics, particularly what our law provides for, what amounts of arbitration agreement, and some of the international trades that we would like to know about. So Albert, you're welcome.
Thank you, Olivia, and thank you, Uganda Law Society, for the opportunity to present this discussion on arbitration or alternative dispute resolution. As Justice Chair Wide and my colleague Julius Jock pointed out, these fall under the ADR process, and we believe this is the future of dispute resolution, whereas the courts are there to provide justice. So the parties equally have an opportunity to decide the kind of justice they receive. Now, arbitration, as hinted on by Olivia, this is a process where parties agree, have their dispute determined by a third party. Unlike mediation, the decision of the arbitrator is final and binding on the parties. And unlike court, the decision of the arbitrator cannot be appealed against. The only recourse under Section 34 of the Arbitration and Conciliation Act is to apply to set aside. Now, the beginning and the end of arbitration starts with an agreement of the parties. And as you're aware, or you might be aware as we go along, is that this process takes into account party autonomy or the party's freedom to decide on most of the matters. Now, one of the things or the starting points is the arbitration clause, or known as the arbitration agreement. Under Section 2 of the Arbitration and Conciliation Act, the arbitration agreement is defined as an agreement by which the parties submit to arbitration all or certain disputes which have arisen or which might arise between them in respect of the defined legal relationship, whether contractual or not. Now, this definition definitely brings in questions that what needs to be in an arbitration clause for it to be enforceable. As you might know, under Section 5, one of the areas or where a court has an opportunity to intervene in this process is when a party seeks to stay proceedings so that a matter is referred to arbitration since there is an arbitration clause. But the catch line under that provision that the clause must be enforceable. So therefore, in looking at the nature of the agreement or clause, the word clause and agreement seem to be used interchangeably, but there are instances where, for instance, you have a full arbitration agreement. It could even be 100 pages or more. And there are instances where it is reduced into one clause in an agreement. So when we use the words they interchangeably, that is where we're coming from. Now, what are the elements of the clause? One, you have to be express in your language. You have to make sure that what you don't need to include in the clause should not be there, so that at the end, when a dispute arises, there is no doubt as to what you meant in the clause. As you might have heard, sometimes this clause is known as the midnight clause. It is known as the midnight clause because parties look at it at the end, having reviewed all the commercial terms in an agreement or contract. They say, okay, let's see how are we going to resolve our disputes if they arise. So in most cases, they just glance at it and say, okay, we believe whatever has been provided for is sufficient. And sometimes counsel does not guide because they are focusing on what the consideration is, what the payment terms are, and the scope of work to be done. So in the end, the nature of the clause comes out not to be helpful when a dispute arises. So it is important at this stage to make sure that you understand the language that has been included in the clause. The other issue, of course, is the number of arbitrators and the appointment mechanism. How are you going to appoint these arbitrators? Is it one arbitrator? Is it a panel of 3? And then there are some instances.
Most obliged. My Lord, we realize that our land brother served the copy with the typed copy. Probably we could do the same so that we save on the time. We just highlight on the most important areas. my Lord, in reply to the submissions of both A1 and the rest of the accused through their counsel, we observe that none of them contests either their participation or presence at the scene in the course of commission of this offense. A1 has only concentrated on advancing what he calls human rights violations, but does not contest any of the evidence adduced by the state. For the rest of the accused persons, my Lord, we observe any of the evidence laid against him by the state. My Lord, for the rest of the accused persons, they only concentrate on attempts to impute the credibility of the evidence and processes on the credibility of the evidence and the processes through which the evidence was got. My Lord, on that aspect we submit that no such objections were raised at the time of tendering the evidence attacked by counsel for A2 to A6, and as such, these exhibits were properly admitted. My Lord, we also observe that my Lord, that our land brother for A2 to A6 has applied a wrong test in relation to the standard of proof required at this stage. And my Lord, you will note that throughout his submissions, he contends that prosecution has not proved its case beyond reasonable doubt. My Lord, that is obviously a wrong test. At this stage of prima facie, and we believe we need not deliver so much on that. We have, my Lord, presented the definition of what a prima facie case entails on our page 1 and up to page 3 through the different authorities. Specifically, my Lord, the Court of Appeal in Criminal Appeal number 39 of 2010, Uganda versus Katoka Jubi Godfrey. It was held that a submission of no case can only be properly made and upheld. Can only be made and upheld if one, when there has been no evidence to prove an essential element in the alleged offense, and two, when the evidence adduced by prosecution has been so badly discredited as a result of cross-examination. Or is manifestly unreliable, that no reasonable tribunal could safely convict on it. My Lord, we want to emphasize that the principle in Bat versus R, whose citation we have given and the defense as well, that case among others emphasized that a prima facie case does not mean a case proved beyond reasonable doubt. My Lord, to answer those two tests I have enumerated in the case of Kajubi, we need to examine the ingredients of each offense. My Lord, in this case, as rightly submitted by opposite counsel, this court is dealing with 3 offenses reflected in the 6 counts. My Lord, in count 1 and count 2, we deal with kidnap with intent to murder, and my Lord, in the interest of time, since the defense do not contest all the other ingredients except participation, we invite court to refer to our written submissions on the rest of the ingredients so that we can use this time to highlight only issues to do with participation. But for the record, my lord, for kidnap, on participation, my lord. So, my lord, in our submissions, we have highlighted the ingredients of the offense of kidnap. We have also highlighted the ingredients of the offense of murder. Which is reflected in our count 3 and 4. We have also highlighted the ingredients of the offenses of aggravated robbery in count 5 and 6. And the total sum of our submissions, my lord, is that each of those ingredients highlighted have been sufficiently proved to the standard required to place each of the accused persons on their defense. Now, to concentrate on the aspect of participation, my lord, we laid both direct evidence and circumstantial evidence. Direct evidence concerned the testimony of PW9, first, my lord, we acknowledge that this offense occurred at night. But contend that the circumstances were favorable for the correct identification of the assailants. My lord, I have cited the authorities that guide us on the factors required for correct identification. And in our case, my lord, PW9 was first and foremost part of the assailants, right from the planning, the movement, and the execution. He knew each of them, and he gave a detailed account of the role played by each of them. My lord, both at the scene of kidnap and murder, his testimony was that he was aided by light from the cars, from the motor vehicle, to see whatever he observed. He was physically present at each event I attested to, in close proximity. my Lord, we admit that, my Lord, we admit that PW9 is an accomplice. But my Lord, as rightly pointed out by our land brother, corroboration under section 132 of the Evidence Act is not a must. My Lord, section 132 provides that an accomplice shall be a competent witness against the accused person, and a conviction is not illegal merely because it proceeds upon an corroborated testimony of an accomplice. So corroboration is not a must. But even then, we submit that there is plenty of independent evidence on record to offer corroboration, as we shall highlight. My Lord, besides the testimony of PW9, there is also other circumstantial pieces of evidence. Plenty of other circumstantial pieces of evidence that in themselves would independently support a conviction of each of the accused persons if they chose to keep quiet at this stage. And I will briefly highlight them. Number one, the call data records, place the accused persons at the scene of kidnap and murder, save for F4 who did not have a telephone contact that night. We implore this court to consider the testimony of PW21 and PW8 on this aspect. The second piece of evidence, my Lord, is the evidence against A1. My Lord, A1 made a charge and caution statement confessing to his crime, as well as detailing the crime of all his co-accused persons. We implore a court to consider the details in the confession statement of A1. And my Lord, we submit that even when prosecution did not have any other piece of evidence, that confession in itself would be sufficient to place the accused persons on their defense. My Lord, I have referred court to the case of PC Mulawa Ben PC Mulawa Ben and another versus Uganda. It's the Supreme Court Criminal Appeal number 3 of 93. Supreme Court Criminal Appeal number 3 of 1993, which contains the principle that confession is capable of containing evidence in itself to justify a conviction of the person making it, as well as a conviction of the maker, as well as the co-accused. My Lord, A1 detailed his role in the planning and execution to the point of sharing the proceeds of crime. That, in our assessment, is sufficient information to prove participation of not only himself, but also his co-accused persons in the context of section 19 and 20 of the Penal Code Act. My Lord, in section 19, any person who actually does the act or who omits to do the act for the purpose of enabling, or who aids to abets the commission of an offense, is a principal offender. So it doesn't matter, my Lord, whether your role was complete or not, whether you only participated in the planning and not the execution, or whether you partly participated, or whether you only facilitated, my Lord, it does not matter. We invite courts to refer to submissions on that aspect. But the third, in the interest of time, the third piece of evidence, my Lord, is the scene reconstruction video which is Prostitution Exhibit 18, as tendered by PW 12. My Lord, in that video, A1, A2, and A3 vividly and unequivocally detail their participation in the crime, and they also reveal the role of the accused persons. My Lord, we want to note that when that evidence was played and admitted in this court, none of the other co-accused persons contested it. None of them. None of them raised a finger to challenge the authenticity. The co-accused persons contested what was attributed to them in terms of participation. So it is an unchallenged piece of evidence which in itself alone would warrant putting them on defense. My Lord, as I rush through the fourth piece of evidence that we implore a court to consider, the element of common intention, provided in section 20. My Lord, we want to highlight that my Lord, section 20 of the PCA, the Penal Code Act, my Lord, we want to highlight that common intention is a mental state, my Lord, and it can be inferred from circumstances. Including the presence at the scene, the omission to dissociate from the crime at the earliest opportunity, etc. Omission to dissociate from the crime at the earliest opportunity, etc. My Lord, the rest of the submissions, I refer you to our submissions, but allow me to quickly, my Lord, respond to what the defense has said. My Lord, for A1, he has submitted to authorities from Kenya my Lord, first, these authorities arise out of an interpretation of a totally different legislation, because the provisions of the Kenyan constitutions are not at par with the Ugandan statute. For example, my Lord, the provisions of the Kenyan constitution are not in tandem with those of Uganda. For example, my Lord, section 72, subsection 3B of the Kenyan constitution was dealing with a situation of detention beyond 14 days, because in Kenya, when you commit capital offense, you can be detained up to 14 days. and here it is 48 hours. But also, my Lord, the circumstances in these authorities are distinguishable, because in the Kenyan case that he vehemently cited, the court was addressing detention of the accused person for 8 complete months, 8 months. But also, in that case, my Lord, the prosecution or the state had offered no explanation. We want, my Lord, to also emphasize that the authenticity of this particular authority also is an issue. This is foreign judgment. It is not signed, it is not authenticated, and reliance on it would have its own challenges. But be that as it may, my Lord, in our Ugandan context, merely proof that an accused was detained beyond 48 hours does not result into an acquittal or discharge. My Lord, refer to the decision in Constitutional Petition number 53 of 2010, petition number 53 of 2010. The parties are Vehangana, Domaro, and another, versus Attorney General, my Lord, this case dealt with this issue at length. But since, for the interest of time, I can just read it, my Lord, and I give the authority. The decision is on page 13, where the Constitutional Court held that the fact that the state has failed in producing an accused before the court of law to prefer a charge against the person does not create a defense to the possible charge against him, nor does it entitle per se the person held beyond 48 hours to a stay of prosecution to possible charges against him. My Lord, the court was emphatic that no such authority exists for the proposition that the petitioners were advancing, and there is nothing unconstitutional per se in preferring charges against a person that has been held longer than 48 hours. And my Lord, there are other principles considered in that matter, but in the interest of time, my Lord, we avail the authority and we can also have my Lord, in another case which held by your land brother, Justice Kwesiga, in this court, in criminal appeal number 130 of 2017, the parties are Nantume Judith versus Uganda, Judith versus Uganda. When a similar issue was raised, this court held that violation of human rights therefore does not bar any criminal proceedings against the accused. the appellant can file a suit for abuse of human rights and claim compensation. And my lord, this case here is, the facts in this case is at par against for a claim compensation. My lord, the facts considered in this case are exactly the same as the complaint being raised by the accused person. And my lord, the rationale is simple, because breach of the Human Rights Enforcement Act is a civil matter, not a criminal matter. If anyone claims breach of fundamental rights, my lord, the suit is against the Attorney General and not Uganda. It is filed in the civil division and not in the criminal division. The remedies are also clear. So we pray that you be persuaded by these two decisions to dismiss the complaints raised by A1. And I will quickly leave A1, my lord, and respond to what our land brother has submitted. My lord, I've already commented that the standard of proof of beyond reasonable doubt advanced by our brother is not proper at this stage. Our brother concedes that there was a kidnap, robbery and murder. We have responded to the insistence of lack of corroboration, my lord, for PW9, and we submit that PW9's testimony has been well corroborated. My lord, how many minutes? My lord, let me summarize in 1 minute.
1 minute.
Yes, my lord. My lord, recovery of the panga. My lord, that discovery of that fact after being led by A2 is a relevant fact under section 29 of the Evidence Act. Of the panga is a relevant fact
after being led by A2
is relevant and admissible under section 29 and can in itself premise a conviction. Number 2, 29 of the Evidence Act.
Okay.
That the chain of exhibit, my lord, was broken. We submit that no such chain was broken. We submit that no such chain was broken, and in any case, my lord, the defense has not demonstrated to this court what they allege to be broken is fatal to prosecution evidence. And second last, my lord, regarding ownership of the motor vehicle, my lord, that we have not produced evidence to show that the motor vehicle was owned by Nagrinya, etc. My lord, robbery is not about ownership of the subject stolen. Robbery is like theft. There is no need to prove ownership. Finally, my lord, the submissions regarding some of the accused persons were mere border riders, my lord, that evidence has not been laid. That, at most, my lord, is submission from the bar. The accused have not laid that evidence. No. It is just coming from counsel. And probably, if they intend to raise it to rely on it as a defense, my lord, they should be happy to be on defense and lead that evidence. My lord, we finally submit that you be pleased to find that the evidence on record is sufficient to warrant placing the accused on their defense. we so submit.
batalagibwa nga bakatambuza abana mutamba mugenda mulagayo otambula yamuga okuva mwatandikira paka obukomerero nako kwoleka bulungi nnyo olubimbi buli omu bwe yazanya naddala okusingira ddala agambibwe ewa kasooka okuyamba namulowooza namba 2 nomwalula namba 3 akatambyako kayinza bulungi namba 2 buli omu ayogera ng'asoomamu ekintu kyaleera mu kitundu kwatambula era nga kano bakatali tekawakalizibwa kubanga kali obutereevu ng'ekizibu kye 45 kaliwa agenda maaso nawayo neteekera 20 nobody act abantu wekomanda nibabeera n'ekigendererwa kyekimu mukuteesa communication kitukole ekitumu mukiganyizaako naye kyokka ekimala okuzuulibwa tiwaliwo okukkaanya kikyuka mugenda okukola naye nga kikyawagizibwa amateeka boti sobola okwesigama gwekyo nezuula waliwo omusango ogugwanidde okulowoozaako kale atandise naawe kasobola okulya ewa n'agamba nti tewali kuwakanya kwonna bujulizi obwaleetebwa obwakanya nti waliwo busi oba abamubalaganya nti omusango ogwedizibwa era wamu naawe ebiri obyobagalera byonna obasaba mukyonizo ozosoma agambe nti tewali wakanyiriza otako tosinga okwesigako obwekalagirako bwekuba oyogera ku kyolebwa kwemere y'omuntu yakuzibwako okunyaba ebisako ekyo kyosinze okwesigako naye tolina wakanyiriza n'okuleta obumu tewaliyo ali abasuubiza okuba nti balagira bantu era oluvanyuma ekyo liga kyagamukotesobola okitolera naye wali omusango ogwadizibwa era nkubabanira okwekuzaako ate wabadayogera okuyiga akiridde namba 2 namba 6 ye liga asinze kwesiba nnyo ku ngeri emizibiti change of evidence olwobera omuzibiti engeri gyebyakwatibwamu ye agambye kino si kyekyamaanyi nnyo kubanga emizibiti ebyo olwakubadde abadde ensonga ebyo byo byakkirizibwa era biwezebwa nebikirizibwa kukooti kuliko bibiri liga wamu namba 2 paka namba 6 abadde abaganya nti omusango guno gukasiddwa okubulamu akalulumu konna ruufu beyond reasonable doubt okudde oli kyabakanyuza akagamba nti guno omutendera gwebiko kigwagwadde omutuufu okuleetera mu ensonga namuleero kubanga ekyaliyo ebitenderera mingi nnyo n'agenda ku namba erabo nti kyayise prima facie case mufasi kesi gwe musango ndikoti gwazudde nti waliwo omusango gwogambidde okulowoozaako ye musango kyoni zaabwe oba enkoza yaabwe okuyita mu biwandiiko yaleso alikoti agambye nti akimunyamiza olungi nnyo okuyita mateeka ag'enjawulo n'emisango egitukula ng'ekyo koti eno bwenaaba ekisomye oba esomye submissions ezo ejja kuzuula waliwo ekibabadde kukulowoozaako kyekyo tuteeka lyalumanyizibwa mu musango wali kugulira namba 29 omwaka 2010 musango gwa kabaka juli godfrey nebane koti eno yawadde okulabirako kuba koti endala zonna eziyinza okwesigama okuzuula kubanga omuntu abavunaaniddwa omusango gwonna alina omusango asobola okukakasa kuba omusango omugambidde okweloozaako ekisongera ddala nti singa oludda lwa gavumenti olwange terukakasizza zimu ku nnyinga ebirungo oba ingredients ezifuga oba koti oyesigama okakasa omusango okugadisibwa singa oludda lwa gavumenti lulemererwa okakasa ennyinga ezo oba emu ku yo kati olwono oludda koti tegwalidde kukaka abantu nga babavunaanibwa ebalowoozeeko ezo tests okukozesa ekirala kyabadde singa oludda lwa gavumenti obujulizi bwe lwaleeta bwa kibugwe nga kwata esobola kubakkiririzaamu oba kubukkiririzaamu kino kyosobola esobola okwesigamu kwekyo negamba nti abantu basaanidde kweloozaako ekirala nti ekireko kenyini okwesigamamu kwokenenya okusegenya kwakisijja tekkiririzaamu obujulizi obwo bwereeteddwa esobola okulabagamba mwozeko musango ogwo naye agende maaso okuka okugenda maaso ngayesigalawo kumusango gwabati libati abaganya republic muno kooti eyo yenyumira bulungi kiki bayita mafasikeesi oba omusango kooti gwebezudde bulisigala abantu bakubasinze naye nga musango guli gwolekate gugwaninamu okwolozaako akaniriza bukatete mbeera eyo kooti ekugire ku nsala y'omusango oyo kwekyo kimusaala ekifusesa okuba omuganda okwolozaako oba neka baze okuyiga wamu nakasobola okubira nti emisango eryonai wagiri esatu emisango ebiri gekuusa okuwamba muntu ate emisango gwokusatu ogwokutta omuntu yekuyira akateekeragamu ebirungo ebikola emisango egyebiri amagi esatu ebiwakanyisiddwa era kwekasobola okubya oba biyina awala obula kyasinza okusibako okukakasa obanga kituufu emisango ebiri wakaddewo egiri mabagambibwa mwazza emisango ebiri gyemumwe abayigiza kyayise participation kati bwati watandize okwata okukakasa kituufu yemwe abaaliwo muzza emisango ebiri bayogere ku kasisiti okugekero
the fact that these people are not disputing all the ingredients of this offenses of criminal and murder. The only thing they are disputing when they challenging was their participation. So he says their submission is above the other ingredients and before those. But now we go to the passage of these people's participation. To put them on the seal of bread and the way I am to defend themselves. Yes, my Lord.
Emisango esatu ebyokunaagwa ebirungo ebikola emisango ebisooka ebiwakanyizibwa abantu bisobola okubyamu akingirira abantu wabula mu sabumisyoni zaabwe zino gavumenti zebalese mulimu emisango kotetejja okusoma nemukaekyagenda okwesibako kakasa nti mmwe abogerwako mwazza mwetaba mukozi omusango ogwo era nga kirinanzwagatisaamukozi esobole okuyita kwekemenya kituufu waliwo omusango gwabanijo also now attacking the authorities.
My Lord, actually, George finished, then repeated.
Yeah, he has
finished everything.
Yeah,
he's just.
The first one was group participation. Who was it? Council. Can you summarize? Just point by point.
My Lord, the first one is the evidence of A9.
Yes, the
second one
was
the second one is the charge and caution for
charge and caution of A1. Next,
the third one scene reconstruction video.
Reconstruction video mentioned where you were supposedly relate the police volunteering to this is the way of working, not to that is also part of what is the right work
among others.
So that is it.
abajulizi basibwa abantu bafa Uganda okugala ku bbiri mu ssaawa 48 naye waliwo ekyo kiriiko omusango guli ogw'e Kenya oyo eyali akiikirira olutalo lwa gavumenti teyawa nsonga lwaki ekyalo kyo